wanted to announce that Heritage Title has launched a full service in-house marketing department to help our clients. So we are really, really excited to offer that. So I know it's kind of a crazy market out there right now. So if you need some support with brochures, flyers, digital and bound home books, we've got some home book leverage your listing strategies to help you get additional listings. Reach out to me, your Heritage Title sales rep, and we'll be glad to help you with that. With that, I want to go ahead and kick off our industry update for this month. Thank you so much, everyone, for joining us. This is always one of our most anticipated updates. Marcia, thank you so much for your time. We know you're very busy, and everyone is eager to hear what you have to say. So I'm going to turn this over to you. We'll let Marcia go through the material that she has prepared for today, and then we'll open things up to Q&A. You can put those questions in the Q&A down there in the bottom of your Zoom. So thanks for being here, and thank you, Marcia.
Well, thanks for having me. I'm just going to give you guys kind of an overview of what we've got going on at the division right now. The first thing being, the Real Estate Commission is going to have a non-rulemaking hearing on June 25th at 9:30 a.m. to look at revisions to the commission-approved forms. We went into 2024 anticipating only kind of focusing on the contract to buy and sell. We'd gotten over 100 recommendations on different changes to that contract alone, and that was what the forms committee was going to work on. And then the proposed NAR settlement kind of reared its head and added some forms to that. So in a few weeks, the Real Estate Commission is going to look at the proposed changes to the contract to buy and sell. Included in that as part of the NAR settlement, and probably before I go into the forms changes, I should just kind of level set for everybody the division's perspective on the proposed NAR settlement. So as far as we're concerned, the NAR settlement has no impact on us. And I think what you guys need to realize is that a trade association cannot enter into an agreement that binds the state regulator. And there are provisions in that settlement as well that basically exempt things out based on state law and practices. So we have commission-approved forms, which is one of the areas that kind of pulls things out as far as Colorado is concerned. Colorado also has transaction brokerage. So I know one of the big issues is, do I have to have a compensation agreement in order to go out and show property? Colorado law does not require that. Now, as an individual, a broker wants to have that requirement, you can do that. But if the consumer calls us and says, you know, she's going to make me sign this agreement in order to go see a property, do I have to sign it? We're going to tell the consumer, no, you don't have to sign that. Colorado law doesn't require that. We don't regulate the MLSs, and that settlement agreement applies to realtors and realtor MLSs. So for brokers that use realtor MLSs, you're going to have implications from that settlement as well, as far as particularly the advertisement of cooperating commissions. So to deal with those changes, we think that our forms are already transparent as far as commissions being negotiable, but we are looking at making changes to make it even more clear that they are negotiable and they're not set by state law. With the contract to buy and sell, we had changed the language in one of the rules, I want to say probably 8 or 10 years ago, that allows you to basically place commission negotiations in the body of the contract as long as it's a point of negotiation between the buyer and the seller. It cannot be motivated by the real estate broker. So you had that rule in place already. To deal with the proposed NAR settlement, what we are proposing to do is have stock language in the contract to buy and sell if the buyer wants to negotiate with the seller the payment of the buyer's broker's commission. And I mean, really, at the end of the day, going forward, that could be a deal breaker for a seller if they are lining up two different offers, and one is a full priced offer where the buyer is paying their own broker's commission versus another offer where it's a full price offer, but the buyer is asking the seller to pay their broker's commission. That may be the deal breaker. It may go to the one that doesn't want the commissions covered. So that's one of the proposed changes to deal with the NAR settlement with the contract to buy and sell. We're also looking at changing the listing agreements. There's going to be some language changed in the exclusive right to sell listing agreement and the exclusive right to buy listing agreement. The option of you getting compensated that may not happen because the seller doesn't pay and the buyer's not planning on paying. We're proposing that gets taken out, and it's either you can ask the seller to pay, but the buyer's still responsible, or the buyer is just flat out responsible. I think checking the box where nobody compensates you would be a painful mistake that people would make once. But this is one of those things that we are just asking the commission to take that option out altogether. To deal with the scenario where you are a real estate broker that is functioning as a transaction broker for the buyer, and you are not seeking to have the buyer sign a listing contract in that situation, what we're proposing to do is put compensation language in the brokerage disclosure to buyer form, which frankly is an underutilized form that we see when we go out and do audits. You should be filling that out anyhow, unless you were getting a listing contract signed right out of the gate. So hopefully that form will be completed more in compliance with the license law, but it will have compensation language in it as well. So those are the forms that are going to go in front of the Real Estate Commission in June. If they adopt the changes, then we are going to move forward and try to get the forms finalized as quickly as possible, because it's anticipated that the terms of that proposed settlement agreement are going to go into play mid-August. If we can do it, we'll try to get them out by August 1st so that you guys get a chance to see them. But this is another year where forms are getting rotated out of our regular cycle, and we don't like to have that happen. It's extremely disruptive. So that is what is coming to you kind of on the front as far as the forms are concerned. There's a couple projects that we're going to start working on, and these kind of got derailed based on other projects that we had to deal with. So we are going to start focusing on broker supervision requirements and really trying to look at making our rules align more with the license law. And this is really probably a good time for us to do this because if it looks like something in the license law needs to be modified, this will speak to another project that we have coming up at the end of the year that I'm going to go over with you. But there's a few things that I think our supervision rule doesn't really address well. 12-10-4036B of the Colorado Revised Statute says that a brokerage relationship that's established between the seller, landlord, buyer, or tenant and a designated broker, including the duties, obligations, and responsibilities of that relationship, shall not extend to the employing broker, nor to any other broker employed or engaged by the employing broker who has not been so designated, and shall not extend to the firm. So really those fiduciary duties do not cascade up to the employing broker, although interestingly, there's another provision in the statutes that say that if there has been a breach of a fiduciary duty, basically the party harmed can sue the brokerage firm and the employing broker individually. So we just need to take a closer look at how the rule is written versus the statutes are written. And then we are also going to be seeking feedback from licensees, particularly the employing brokers, because they're the boots on the ground on this, to see how they are managing supervision. There's been some concerns that we've had that have come about as far as complaints, where not all employing brokers do the same thing. Some strictly supervise, others produce. And we've had complaints where an employing broker has been a member of a team within the brokerage, and the brokerage firm ends up representing both sides of the transaction, with the team representing one side, another designated broker representing the other side. And that is really a weird setup, considering that the employing broker is part of the team and they're supposed to be supervising both sides, particularly when you've got single agency coming into play. So those types of scenarios have raised some issues, and the Real Estate Commission has found violations of the license law. So we need to look more carefully at what our expectations are as far as broker supervision is concerned, and managing confidential information and those relationships, to make sure that our rules really are in line with what the statutes require. And if the statutes are antiquated and need to be updated to compensate for how the industry is practicing, and it can be done in a way that is protective of consumers, because that is what we are here to do, then what we're going to do is we will add that to a suggestion list that will come into play when we go through the sunset review process, which I'll get to in a minute. The other thing that we're going to look at is a data security position statement. The Real Estate Commission in February adopted a couple new definitions, and two of these definitions will go into play when we look at doing a position statement about data security. One is personal identifying information, and the other rule defines what safe and secure manner is. We really want to lay forth some guidelines for you guys, because I realize that we are not able to set forth rules to really deal with kind of the organized crime element that does the fraudulent email addresses and the misrouting of funds at closing, as they portray themselves to be either part of the closing process or whatever. But there are some things that our brokers are doing that we can address through data security. It's just not a good plan to sit there at Starbucks on their Wi-Fi managing confidential information through your Gmail account. And we haven't seen it so much on the real estate broker side, but this was an issue that we saw quite a bit on the mortgage broker side. They would go out of business and they would just dump their transaction files in a dumpster. And there's a lot of PII involved in those transaction files. That's not the appropriate way to destroy that type of information. Fortunately, none of our real estate brokers made the news the way that the mortgage brokers did, but I think it's time that we kind of set forth our expectations, at least in a position statement, about how you guys manage that type of information. So the big project that we have coming down the pike for us will start this fall. And it's nothing new. We go through this periodically. The last time I think was 2018 was when they ran our sunset bill. So the Office of Policy Research and Regulatory Reform, the acronym for it is COPPER. It is a office within DORA, but it's separate from the DORA divisions. They will start to do a sunset review of the Real Estate Commission, and the division is included in that sunset review. And basically what they do is they've got an established set of criteria that they evaluate during a sunset review. But the big question that they are trying to answer is, does regulation of the industry need to continue? I joke with the real estate broker program that if anybody comes back and says, oh no, they don't need to be regulated, they can self-regulate, I will fall out of my chair. We have enough examples of the division to show why regulation of real estate brokers exists. But that's going to be the first thing that they're going to look at. And once they kind of answer that question as far as should regulation continue, if the recommendation is that yes, it should continue, then they also look at how the program functions, and they make recommendations on ways to enhance the program or bring it up to modern times if we had something that was antiquated. This is really a stakeholder engagement process that they will undertake with this. So they don't just ask the division for our thoughts. They will reach out to industry members, and they also want to hear from consumers. And unfortunately, those are the most unrepresented voices in our sunset review process. So if you have anybody that has gone through the real estate process and would like to express their opinions about how it went for them, good or bad, please encourage them to participate in the sunset review. Later this fall, once we get assigned a policy analyst, we'll include a link on our website, and that will take you over to COPPER, and you can provide comments. I'm pretty sure they'll set up a survey for you guys to complete. I know with the recommendations that we make, we're going to have to articulate why those recommendations should be made. We are pretty much kind of early in the process, but I know that one of the things that we have identified so far that we would like to see changed is how we deal with continuing education non-compliance. So currently what happens, you get randomly selected for an audit. And based on some of the accounts that I hear from our licensees, once your number comes up for that audit, you're either digging in your attic or your basement trying to find your CE certificates to prove that you have your required 24 hours. You submit those 24 hours to us, and if you're compliant, you're good, nothing happens. If you're non-compliant, you end up having to pay a fine and making up coursework. Then we've got the other category that never responds. They don't respond to us. They end up, you can get disciplined for failing to respond. So they end up on that path. And then when they don't respond, after discipline has been kind of handed down, we have to refer those over to the Attorney General's office, and they go through the whole litigation process with the Office of Administrative Courts, which ultimately, if they go through the whole litigation process for a CE violation and you're still not responding, typically what we see is an administrative law judge that hears that case will say, well, they weren't responsive during this process either. They obviously don't care to keep their broker's license. And they will usually issue an initial decision that says revocation is appropriate in this situation. The division would like to handle it differently than the process that I just explained to you. It's not a good use of our legal resources, particularly when we are dealing with cases with much more egregious behavior, like stealing client funds. We have some people that fail to disclose material facts on properties that they own when they're a broker. Just other cases with extreme consumer harm. What we would like to do is manage CE non-compliance the way we do with errors and omissions insurance non-compliance, that if you don't have it, we just knock you over into inactive status. And to go back to active status, you have to demonstrate compliance. So that is one of the things on our wish list so far. But like I said, it's pretty early in the process, and I'm sure there's going to be other things added. So when they do the sunset review, they look at every aspect of our program. They look at how we issue licenses. They look at why the Real Estate Commission denies licenses for those people that have had prior criminal involvement or prior professional license discipline. They look at continuing education, and if that is the appropriate way to demonstrate someone's competency to continue practicing in the industry. They look at the complaints that we investigate, how the commission renders discipline, and how we resolve the complaints. So they pretty much look at every facet of the Real Estate Commission's program within the division. Once they do this review, which largely will take most of next year, they will issue a report on October 15th of 2025 with their recommendations. And like I said earlier, I fully anticipate that what they're going to do is say that real estate brokers need to continue to be regulated. So they'll put forth those recommendations, and if the recommendations are to continue the regulatory program, then come January, you will see the sunset report be presented to our committee of reference, which is like the Business, Labor, and Technology Committee in either the House or the Senate. And that will be January of 2026 that will start. The committee that looks at that sunset report at that point can pull things out. Like if they don't like a recommendation, they can pull that out, but they can move a bill forward to continue the program. And that actually did happen in 2018. One of the recommendations is that property managers should have to have an endorsement above and beyond the real estate broker's license. At that original committee hearing, the commercial property managers really kind of came out in force and voiced concerns to the committee about that endorsement and the proposed requirements with that. And the committee stripped that recommendation and moved forward with a bill to continue the Real Estate Commission, but not include an endorsement for property managers. So that is something that can happen. What I would also remind everybody through the sunset process is the philosophy that Colorado has regarding regulation. We are a regulation light state. The goal in Colorado is to regulate professions at the lowest threshold necessary to protect consumers, and they don't want to create a barrier for entry for people. So that is another thing that will come into play with those recommendations. I know previously, the Colorado Association of Realtors had provided recommendations, and they do each time we undergo a sunset review. But one of their recommendations was to raise the bar on the educational requirements to get a broker's license. If you start to look at our state compared to other states in the nation as far as education requirements are concerned, Colorado has a higher number of educational hours than a lot of other states. Like if you look at New Mexico, they have like maybe a third of what we have. At one point, I think we looked up Connecticut, they had like 28 hours compared to our 168. But that also speaks to the fact that brokers back east function differently than brokers here. You have a limited license to practice law. You get a complete contract documents, where back east, they're likely to involve an attorney in those transactions. So just keep that in mind. If you make a recommendation and you don't see it end up in the report, it may not align with that whole light regulation philosophy that the state of Colorado has. So the last thing that I have for you guys, kind of policy-wise, is the Real Estate Commission isn't the only program that we manage. We have the Board of Real Estate Appraisers and the Board of Mortgage Loan Originators. And right now, I am trying to find candidates to fill vacancies on the Board of Real Estate Appraisers. We have 4 spots coming up. One is for an appraisal management company representative. One is for a banking representative. And I have a couple people that are interested in filling those spots. I need an appraiser that has eminent domain experience. We are missing applicants for that one. And then members of the public to serve on the Board of Real Estate Appraisers. And when I say members of the public, that can't be somebody that holds one of our other licenses. So you can't be a real estate broker or mortgage loan originator to sit in that member of the public spot. But if you guys know of anybody that would be interested in sitting on that board, I would encourage you to send me an email, and I am more than happy to send you a link to the application. It's easier for you to email me and for me to send you the link than for you to try to navigate the state website and find it yourself. So if you're interested, my email address is marcia.waters@state.co.us. And that's kind of policy-wise what we're looking at. There are a couple things that I wanted to flag for you guys as far as practice issues, just to be aware of. We haven't seen any complaints yet about artificial intelligence and our licensees using it, but I'm hearing some rumblings. I've also seen what ChatGPT can do as far as a property description is concerned. So if you're going to use artificial intelligence, that's fine, but you're ultimately responsible for the outcome. If you end up with an advertisement that runs afoul of fair housing, you don't get to use the excuse of, well, I didn't do it, it was ChatGPT. No, you used it, it's on you. So be careful as far as property descriptions. I've seen a couple scenarios where, like the first couple of iterations of having ChatGPT work on a property description has been fine. There hasn't been issues. But then like the 3rd, 4th, or 5th iteration, it seems to have gone off focusing on the property and more on the type of people that might want to live in that property. And it's when you integrate the type of people that's usually going to take you down the road of a fair housing violation. The other thing about ChatGPT is it does not replace using a licensed Colorado attorney to draft contract clauses or contract documents. That is not an exception. So if you need a contract clause drafted, or the Real Estate Commission doesn't have a form that you need for a contract document, you need to hire a licensed Colorado attorney, and it says in the statute they have to be a Colorado attorney. You can't use ChatGPT instead of that. And frankly, I think if we see a complaint where you're using ChatGPT to do contract clauses or contract documents, that's basically the same as you creating your own contract documents or clauses. The Real Estate Commission would likely deem you to be unworthy and incompetent in your practice as a real estate broker. I don't know if they would consider referring you over to the Supreme Court for an authorized practice of law because you're using technology to kind of circumvent regulation at that point. But that is something that could happen. So please don't do that. Some of the other things that we've been seeing, unfortunately, that we continue to see, lockbox complaints. So it is unacceptable with the commission regulations for you as a buyer's broker to just give your buyer a lockbox combination and send them on their way to see a property unattended. Typically what happens the first time we see one of those violations is the Real Estate Commission will fine you $500. We haven't had too many repeat offenders or multiple offenses of that rule, but typically what happens is The real estate commission will increase the amount of the fine to make it more punitive. But the one common thing that I've seen over the years with the real estate commission, regardless of the behavior, if they have told you multiple times not to do something and you continue to ignore them and you just go on your way with violating the license law, they reach a point where they have no interest in keeping you in the industry and they will revoke your license. So just please, I would hate to see somebody lose a license for something like that. And not really with the climate of real estate right now, particularly with the lawsuits and everything else. I think real estate brokers need to do a better job at explaining the value that they bring to transactions and why people use real estate brokers for transactions. And you are sending a horrible message to a consumer that you don't have time to go show them a property as their buyer's agent. Because if you don't have time to show them the property, how are you going to navigate them through the transaction? And as a buyer, if that was the message I was receiving, I wouldn't be working with that real estate broker. So it doesn't reflect well on the industry. Another prevailing complaint that we see has to do with disclosure of material facts. We are seeing more and more of these complaints where these are fix and flip properties that the brokers have done. The real estate commission has made a distinction between when you've failed to disclose a material fact on a property that you have listed but you don't own versus a property that you own and you fail to disclose. They are less lenient on you when it's your own property. Frankly, we've seen situations where because it's the broker's own property, they have gone straight to revocation. So disclose, disclose, disclose. It's not what you think's important. Make the disclosure, allow the consumer to decide what is important to them. And this is one of those areas where, a verbal disclosure is technically meets the standard as far as compliance is concerned, but I would be covering my end and reiterating that in writing. So keep that in mind. That's one of the most challenging complaints that we get. A lot of the time when we get a failure to disclose material fact case, when we first review those, we're trying to decipher, is this a failure to disclose on the part of the seller versus on the part of the broker? If it's on the seller, it's not something that we're going to investigate because we don't have jurisdiction over the sellers. If it looks like it was the broker that failed to disclose, that gets assigned for an investigation. And if we can substantiate the violation, it goes to the real estate commission. And then just a basic couple compliance things. Every year we do errors and omissions insurance audits. After you guys renew, a couple months after renewal season, typically in February and March, that's when the licensing team starts to get data feeds from the insurance carriers. We match those up in our system. And if you don't have a policy of errors and omissions insurance, we're going to move you over to being inactive. You can't practice without errors and omissions insurance, and that includes procuring deals. So don't communicate to us, yeah, I'll get errors and omissions when I get a deal. No, even getting the deal requires the active license and the insurance policy. And then quarterly, we do continuing education audits, and that is to make sure that you have done the required amount of education for your real estate broker's license, which for a 3-year license cycle, it's 24 hours. 12 hours are the annual commission update courses. You can't repeat the same course more than once for CE credit within the same cycle. And then the other 12 are commission approved elective hours. Sorry, I have an animal assisting me right now. Make sure that you go onto the commission's website and verify that the elective hours that you're going to take are actually commission approved. That is really kind of an unpleasant surprise that a lot of people encounter when they go through the CE audit process, is they may have more than enough hours and then find out that they weren't all commission approved, and then they end up with a shortage. Either case, errors and omissions insurance, CE certificates, do not falsify them. Should you not have errors and omissions insurance or a sufficient number of CE credits. Time and time again, we see people that falsify their insurance policies and their CE certificates, and you really end up taking something that is a kind of a low-lying compliance issue, and you're making it now a nuclear option for us, where the real estate commission looks at that and says, well, you're dishonest, you forged certificates, we don't want you in the industry anymore. And it may be for something as simple as not having one CE course. So please don't do that. I'm going to end this with a couple just basic stats on our program so that you guys have an idea of kind of where our populations are at. I'm going to give you numbers as of the end of April because we haven't done the end of May ones yet. So end of this April and then a year prior. And then I'll also give you the number of active complaints as of the end of April as well. So with the real estate broker program, which is our largest program, at the end of this past April, we had 51,643 licensed real estate brokers in Colorado. Typically, the trend is about 25% of those are typically on inactive status. A year prior, we had 51,830 real estate brokers. So I don't think you could say that we have a shortage of real estate brokers. I know that everybody is kind of concerned with the changes in kind of the landscape, given the NAR settlement and that sort of stuff, what's going to happen to the licensing numbers. I don't have a crystal ball to tell you that. We're going to wait and see what happens with this renewal cycle come December 31st and see what happens with our licensing numbers. But we've got brokers on 3 different renewal cycles. So it could be something as we don't see a big population change until 3 years from now when everybody has gone through renewals following the settlement agreement. With the real estate broker program, we have 181 active complaints. And I will tell you, the real estate broker complaints are probably the most entertaining of the 3 programs that we have. The real estate brokers have a tendency to be far more creative than like our appraisers, but that's a good thing. We don't want the appraisers to be as creative as the real estate brokers. It wouldn't be good. With the mortgage loan originators, which are our second largest group, but our youngest as far as being regulated, we have 17,799 of them as of the end of April. A year prior, we had 20,660. And I think the big drop off is probably correlates to the fact of the interest rates and kind of the market cooling. It's also a relatively easy license to let go and then pick up later. They only have 20 hours of qualifying education, and their licensing test is good across the nation. It's a uniform test. They've got a lot of license portability with that license type. We had 18 active complaints against the mortgage loan originators at the end of April. Their complaints are kind of similar to the ones that we get for the real estate brokers, but obviously the volume is significantly less. Most of what we see with the real estate or the mortgage loan originators has to do with post-licensure criminal convictions and competency issues. And then our last program, which is our second oldest but our smallest, are the appraisers. And as of the end of April, we had 2,929 of them. A year prior, we had 3,028. So it's a pretty consistent licensee pool, and we have 17 complaints against them. One of the issues going on with the appraiser program, their licensing requirements are set at the federal level. Currently, what they're doing at that level is evaluating if the criteria should change. They're dealing with the graying of the industry, and they are also trying to find ways to modify the licensing requirements to encourage a more diverse pool of applicants to come into the appraisal profession. So that is something that we are monitoring as they're working on, and they've been working on that for some time now. So that is our population. And Jill, do you want to open it up for questions?
I was going to start with a comment. So speaking of creativity, Karen mentioned that she met an agent who had his buyers sign an unlicensed buyer's assistant agreement, and then he gave them the lockbox code.
So that doesn't comply with the license law either. I would be really curious to see that agreement as well, because it probably should have been drafted by an attorney.
Okay, I'm going to start reading through questions here. So regarding the exclusive right to buy, is there any way in 733 it could say broker is authorized and instructed to request also instead of just broker is authorized? I've never understood why one has that and the other does not.
I think we did add that.
Damian spends more time in the forms since he used to do the drafting.
I thought
Okay.
we did that, but maybe I need to go look again.
We'll circle back on that one.
Yeah.
Is it still okay? Brokerage disclosures are given out, not required, but not requiring the buyer to sign it. We often get email leads and reply with a disclosure and statement about the disclosure. Like at open houses, they're handed out and we document giving them out.
So yeah, if they refuse to sign, it's not going to change anything. Just simply indicate refuse to sign.
Someone said, thank you for being here today. You mentioned the possibility of sellers turning down offers where they are asked to compensate the buyer's agent. What if first-time buyers or buyers in the various groups of color that oftentimes struggle to just to come up with a down payment? Seems this opens the door for discrimination.
I think there's a lot of aspects about the settlement that are kind of unknowns. And I don't think we're going to fully understand kind of the breadth of the fallout of it until after it goes into effect. Because there's going to be a lot of people that are not going to be able to afford paying a broker's compensation or broker's commission on the buyer side. And really what that may come down to is that's when the buyer may say, I can't afford a broker. I'm going to have to navigate this on my own. Which is kind of like a for sale by owner, where that unrepresented buyer may kind of put additional pressure on that listing broker, and that listing broker is going to have to walk a careful line of representing their client, the seller, and dealing with that buyer as a customer. I expect that we're probably going to see quite a few complaints as well for people that are unrepresented when issues arise in their transaction just because maybe they didn't have that opportunity to afford a broker and something goes wrong. I anticipate that we'll see complaints about that as well. It doesn't necessarily mean that they're going to fall within our jurisdiction though.
Yeah, a lot of it's going to be based on what kind of market we're in too. You could see that issue coming up more when you're in a strong seller's market versus a strong buyer's market, and probably change over time based on the market conditions.
Okay, we had another question. Oh, sorry, go ahead.
I am a little concerned of this concept, and I am also waiting to see like what happens after this settlement goes into place, because I think we're going to hear something from the Department of Justice and also the Federal Trade Commission, and those are the ones that the commission and the division need to pay attention to. Those are the federal regulatory bodies that can speak to antitrust and price fixing and that sort of stuff. This whole concept about requiring a consumer to sign an agreement right out of the gate just to see a property, I don't think that is consumer friendly by any means, because how is it consumer friendly for a consumer to sign a contract with a broker when they haven't had a chance to feel the broker out, see if their skills meet that consumer's needs, simply because a consumer wants to go see a property? So I see some concerns with that. I think that's going to also give us an increase in the amount of complaints that we get from consumers that are stuck in listing agreements that they want out of, that brokers won't release them from, and the real estate commission can't interfere with those types of contracts. The one thing that I will say though is if you're not going to let somebody out of their contract, I hope that you are performing all of your duties under the license law, because that is the one thing that does fall within our jurisdiction.
And I'll say to that too, is that, you know, if you have consumers that only want to go see 3 houses, guys, you don't have to do a listing contract for, obviously this is, you know, a year and all over the state. I mean, be mindful of what the consumer is looking for And because you can't head off those complaints that Marcia's going to get when they come back and say, I'm stuck in this agreement for a year and I can't get out of it. And I hate this broker. That's just going to create problems for you. And if you do want to sign an agreement, which I think is still a good idea, you could just limit it to over the weekend or only in Grand Junction or something along those lines to keep it so that it's more on par with what the consumer thinks that they're getting into.
But fortunately, you don't have to have one of those in Colorado in order to see property. So if at the individual broker level, if the broker is going to require somebody to sign an agreement before they even go take people out to show properties, if the consumer calls us, we're going to tell them that they are not required by law to sign that agreement.
Okay, we had a question here regarding contracts. The NAR settlement opened my eyes and raises questions about the accessibility of real estate contracts to the general public. Given that one must possess an active real estate license to write and present these contracts, are there measures in place to restrict access to these documents only to licensees? I have observed instances of unrepresented parties utilizing these contracts obtained from DORA inaccurately, and I fear this practice may become more prevalent. Should these contracts be exclusively available to licensees to ensure proper usage and compliance?
So the Real Estate Commission promulgates those forms for brokers to use in their transactions in representing consumers. There isn't a restriction about consumers being able to pull our contracts off the website. I have cautioned some that I have spoken to on the phone about they were just going to pull our contract off. We can't give them legal advice to help them navigate that document. They may be better served going to a different forms provider to find a different type of contract to achieve their goals, but we can't limit a consumer from using the Real Estate Commission approved forms.
I had a question here. Why did it take until May this year to audit E&O renewals?
So we are in the process of trying to go to a new licensing system, which has monopolized a lot of the licensing team's time as far as 3 people have been heavily involved in development and testing of that new system. Having them kind of tied up on working on the new system delayed the errors and omissions insurance audit.
There was a request to provide a document with these statistics, I'm assuming about the different license branches and.
So if you give me until probably tomorrow, when I will be working on a report that I have to do on a monthly basis, I can send you the updated May numbers and I'll send them to you, Jill. And
Great.
then you can send them out to everybody that's registered.
Awesome, thank you. Can you please clarify Colorado's position about requiring a buyer agency in order to show property?
Well, you don't have to have buyer's agency in place in order to go show a property. Colorado law requires a real estate broker's license when you are bringing 2 parties together and you're negotiating the terms of an exchange of real estate. And that exchange could be a lease, it could be like a 1031 exchange, it could be a sale, but it's the introduction of the 2 parties and negotiating the terms of it. Actually, just going out and showing a property doesn't require a broker's license. And you're required to have that signed exclusive right to sell or buy contract. On the exclusive right to sell side, you've got to have that done when you are a single agent for the seller or you're a transaction broker for the seller. So regardless, if you're going to be representing the seller, you've got to have a signed listing agreement. On the buying side, the exclusive right to buy contract is mandatory when you are a single agent for the buyer. Transaction brokers representing buyers don't have to have signed listing contracts, although they may choose to do that just to kind of memorialize the terms of their employment agreement between that broker and the buyer, their client. But you don't have to have a signed listing contract in place in order to just see a property.
Okay. What are some of the more prevalent real estate agent violations this year?
So disclosure of material facts is one of the leading ones. We still have a lot of real estate brokers that get into trouble post-licensure because they have involvement with the criminal justice system. And I will say, I think one of the big points of confusion with that is it doesn't just apply to felonies, it also applies to misdemeanor, and it kind of runs the gamut. So when in doubt, you are better off reporting a plea of guilt, a conviction, or a plea of no contest to us, and we can let you know whether it is something that was required to be reported or not. You do not have to report DUIs to us. That is seems to be common in the real estate industry. So post licensure, if you get a DUI, you don't have to report that to us. Now, if you get a vehicular assault or vehicular homicide that is a component of a DUI, those have to be reported. But so just be careful. Misdemeanors and felonies, there's a likelihood that you have to report those to the real estate commission, and they have to be reported within 30 days of either the being found guilty or entering the plea. We get a lot of divorce cases lately. And the one thing I would caution brokers about representing divorcing parties is just make sure that you are treating both sides fairly and you are performing all of your duties with both individuals. A lot of the complaints that we get is one side feels that they were left out of negotiations, they weren't consulted, they didn't have a voice in the transaction. And I think part of it also speaks to like one side of that divorcing couple is easier to get along with and the other one may be a little more challenging. But you need to make sure that you are representing both of them equally and fulfilling all of your duties to both. Lock boxes I brought up earlier, and those are really kind of the common ones that we see time and time again.
Okay, so I think going back to the FSBO scenario, when representing a buyer, talking to a buyer only. So then we have dual agency or remove transaction brokerage completely.
So dual agency is not allowed in Colorado. So please do not pursue that option unless you want to go in front of the real estate commission. I don't understand. I guess
I don't understand the question
because we're not getting rid of transaction brokerage either. Transaction brokerage is an option here.
I didn't quite understand the question either.
Yeah, if you want to rephrase that one, we're happy to take another look at that. And we have a comment here. The problem between Colorado and MLS is that the agreement has made the MLS responsible to ensure a written representation agreement is in place before showing.
So that's a disjunct, and that's not like we don't have to change our laws to accommodate MLS, and that is not going to happen.
After what time will there be new forms regarding the settlement?
So the forms, if they're adopted by the real estate commission, and if we can get everything reviewed and finalized, it's going to be, we're hoping to get them released by August 1st.
Yeah, the stars have to align though, so.
Yeah.
What if the DOJ really keeps pursuing more restrictions, like not allowing sellers to actually pay buyers' agents compensations?
So if there's federal laws that go into place, if they're able to either establish policy through regulation or they pass laws at the federal level, that will prohibit who can pay what commissions. Typically, what we deal with is we enforce our state statutes specific to the Brokerage Practice Act. And one of the concerns that I heard last week was there were some brokers saying, well, what if we don't abide by this agreement? Okay, well, we don't enforce the agreement. If we start seeing behaviors that if they pass a law that prohibits who can pay what commissions, and we start seeing complaints that appear to be contrary to what the federal law requires, we will refer those complaints on to the federal agencies because they have jurisdiction over those laws. I
And
want
my
to poke the bear when it comes to the federal government and their regulations, because the real estate commission, when they discipline something, particularly when they go after a broker's license on a revocation case, they'll revoke the license and they'll impose maximum fines. And the maximum fines that the commission can do is $2,500 per violation. So if you have done a bang up job, really doing a horrible job at a transaction, those fines can rack up into the, tens of thousands. The federal government, though, has a bigger stick to swing than the real estate commission does. And those fines usually are significantly more than what the real estate commission can do. And depending on what they're looking at, who knows what other types of penalties that they can impose. I would not thumb my nose at the Department of Justice or the Federal Trade Commission.
Yeah, some of them have you're in jail attached
Well, I
to
was going
them.
to say that there's potentially criminal ramifications.
Yeah, and obviously if the DOJ or FTC or somebody else changes something that makes our forms not compliant with federal law, then the forms would have to be updated.
And so we will be monitoring what the Department of Justice does or the Federal Trade Commission. And if there's things that we need to change, we will do that, because the division does not want to be at odds with either of those entities either.
Okay, just to reiterate, anyone unlicensed, assistant or otherwise should not be given lockbox access, correct?
Well, as far as assistants are concerned, that's going to depend on what the seller has authorized. So it's not black and white. There are some, it depends on the circumstances.
Does DORA have an appetite for licensing inspectors?
So I don't know where the last Sunrise application was done on inspectors, but it likely is time that if they wanted to pursue licensure again, I'm guessing that a Sunrise application would need to be submitted to Copper, and they would have to do a review of the industry. In the past, when they've talked about regulating inspectors, it's been that they would be adding that program to the Division of Professions and Occupations, not real estate. So I don't know. I haven't heard anything the past couple of years about inspector regulation.
So for clarification, are you saying we don't have to have buyers sign an agreement to go show a home per Colorado law, yet the NAR settlement is requiring this?
Colorado law does not require a signed compensation agreement in order to show property. You're going to have to, so for those brokers, as far as the compensation agreements and the NMLS rules, those apply to realtors and brokers that use realtor MLSs. Colorado law, though, doesn't, and that's part of that settlement agreement is there's exceptions to the application of terms of that settlement that Colorado law doesn't require a compensation agreement in place in order to show property. So as far as we're concerned, realtor or not, you don't have to have a compensation agreement in order to go show properties here. And please, after the settlement goes into place, please do not send complaints into us about Marcia didn't have a compensation agreement before she went and showed property, because that's not going to be a license law violation, and that's not our problem to enforce.
How many of the licensed real estate brokers in Colorado belong to a local, state, or national board?
I don't have the recent statistics. I wanted to say the last time I heard it, there was about 21,000 brokers that were members of the Realtor Association, but I haven't checked those stats in quite a while. It is definitely not our entire population.
The settlement affects realtors, members of NAR. Can licensed agents practice real estate in Colorado without being a member of MLS or NAR and not be impacted by the NAR settlement?
Yes.
With regards to forms, will the post-closing occupancy agreement be adjusted to follow the new landlord-tenant ruling? Oftentimes, we allow a seller to stay in the home at no charge and just have them pay a damage deposit. The new ruling does not allow you to go collect a damage deposit if you have not charged rent.
That's not a new ruling. That's a statute that was passed, but I don't think the post-closing occupancy agreement needs to be changed to accommodate that. But you guys sent something out on that too, didn't you, Marcia, as far as warning people about that? I thought I saw a piece come through that.
That I'm not sure of.
I'm pretty sure, but anybody that's doing post-closing occupancy agreements, just so you know, the new law that was passed that says, it was passed last year, that says that that you can only charge 200% of the rent for a security deposit does apply to post-closing occupancy agreements because they are leases, which means if you are allowing the seller to stay there rent-free, then that means you're also doing no security deposit. So that is a risk to a buyer if they charge the security deposit or if they don't charge the security deposit. And you really ought to probably be advising them to seek legal counsel if they're not comfortable with it.
So we had re-clarification on that earlier question. So a buyer does not want to pay a broker fee, but then goes to the listing agent and says, the seller's agent, should do the whole deal. Then what or who is the real estate agent representing?
So that broker, unless they are suddenly going to be a transaction broker for both, and the seller agrees to that, otherwise that broker is going to be representing the seller, and they're going to be treating that buyer as a customer. So they're going to owe fiduciary duties to the seller, not the buyer.
How do you foresee agents offering compensation when it's not allowed in the MLS?
Well, I think one of the things that has been discussed in light of all of this is that it's just going to be a per deal type of discussion. You can't just expect that, if you put in an offer on this property, automatically the cooperating brokerage is going to be X%. It's going to be on a deal or offer for offer basis as far as terms of negotiation. With that said, though, ultimately, when you sit down and do the listing agreement between the broker representing the buyer, you're going to be discussing at that point the expectations of what that buyer's broker is going to be compensated. And the other thing that I think you guys need to be aware of is if it becomes a point of negotiation in the offer, if there's a difference between what the buyer's broker has negotiated with their buyer versus what's being offered or negotiated in the offer to purchase itself, say the buyer and their broker have negotiated that the broker is going to get X%, and when they submit the offer, the seller agrees to pay Y%, which is less than X%. The broker needs to have a conversation with their buyer about who's going to make up that difference, or are they going to waive that difference? And also, if they've agreed that the buyer is going to pay the broker X%, but then in the negotiation of the purchase, the seller says they're going to pay Y, and Y is more than X, that's another conversation that they need to have, because that additional compensation has to be clearly disclosed to that client as well.
And it has to be authorized. I think we've updated that to say you can't take extra unless you get permission and approval.
So it's really not an opportunity to try to score a windfall.
Okay, we're at our time. We'll snag maybe a couple more questions here and then we'll let you go, Marcia. We know you're busy. When the new forms are released sometime in August, will brokers need to update new signed forms with our clients that are already under contract or have a current listed property in the MLS?
Typically we don't tell you that you have to renegotiate an existing contract. It's up to you on whether you want to do it. One of the concerns with that is somebody may be like, no, I don't want to continue to work with you. This is their opportunity to get out of that contract. So with the contract to buy and sell, After that August 1st date, that is the contract you should be using to submit offers. But if you've got an existing one, that contract remains in play.
Here's a question from Karen. Could offer of compensation be in contracts programs?
You mean as far as like CTME
Like
contracts?
CTM?
Yeah, that's going to be up to them.
I don't think anybody's going to want to touch that third rail right now as far as putting in offers of compensation as an aggregator. I just can't imagine anybody wants to be the new target for antitrust. But that's just my guess.
Along those same lines, are we calling the listing agent and asking what the compensation is for their listing? Where do we place the compensation in the contract to buy and sell, and additional provisions?
I don't think there's a reason that a broker couldn't ask if there's a cooperating commission being offered, but that shouldn't be the motivation for submitting an offer. If the client wants to place an offer on that, the roadblock shouldn't be, well, they're not paying the cooperating commission that I want. And if that happens, that's a violation of our license law. You don't get to put your commission above your client's needs.
Okay, perfect. All right, we're a few minutes over time, so we're going to wrap up there. Thank you so much, Marcia, for your time. Thank you so much, everybody, for joining us today. We will look forward to seeing you at our industry update next month. And if you have any follow-up questions, feel free to reach out to me or your Heritage Title sales rep. We'll be glad to help. Thank you so much, everybody. Have a good rest of your week.
Thanks, Marcia.
Thank you.
Thank you, Marcia.